just love it when Donnie McClurkin goes, oh, that is such a nice note. 11 minutes after 7 o'clock as we settle into hour number 2 of the Breakfast Round Table here on Sky 99.5 FM. It's Wednesday, March the 14th, 2018. It is the morning after the night before where there was speculation, rife speculation, that maybe the CJ would be prevented from leaving the country. Maybe they would put him under house arrest. Maybe they're going to trigger Section 137. And the speculation continues as this novel being written, or soap opera, or gripping television series.
All of the above.
All of the above. A little bit of Eric Van Lesbeda, a little bit of Jean Le Carré, a little bit of Michael Crichton, a little bit of maybe a little bit of Anne Rice too, right? Because thank you very much, Martin George. You know the folks.
Tom Clancy.
Wow.
Tom yes.
Well, I don't know anything about these people you're speaking about there. I'm not a movie fan.
Sometimes.
But we're glad because we need a verdict here this morning, so we're glad to get you.
Fact is more potent than fiction,
And listen. All we need now is for I think it's Ty Waititi, the guy who directed Thor Ragnarok, to come in and shoot some video and put in some interesting stunts with, of course, some hot zingers. And it's the perfect movie. Yeah, absolutely.
Never a dull moment.
Never a dull moment.
I tell you, good morning to you all, and good morning to
Morning,
Martin.
Good morning, Martin George. Martin George, what now? Question mark. The only thing missing on the headline this morning on The Guardian was the exclamation point, which I guess is silent because, everybody wants to know what now?
Yes. Well, the thing is, actually, Jessime, I am not entirely surprised that this was the reaction, because I think it's clear that we've seen over the past, months or years, that there hasn't been the best or most cooperative working relationship operating between the executive and the office of the head of state. So it's not entirely surprising that they would not see eye to eye on this issue. And
so you're saying this is a power play, Mr. George?
Well, no,
of sort?
I wouldn't put it
in
penal terms. But the thing is, it is clear that there's been a flexing of the muscles, and I think the response from the president is clearly an assertion of a superior authority as far as the office of the president sees it, that, look, hey, I have made my decision, and if you don't like it, then that's your business. But my decision stands, and it really, I think, boxes the prime minister into a corner and impales him on the horns of a dilemma, because I think we did have a statement from a senior government official, saying that they were of the view that the president's office did not have the authority.
Exactly.
The president has said, look, I am standing by my decision. My decision is final. So where do you go from there? I have seen some speculation in the newspapers, whereby they have quoted nameless, faceless senior counsels who have, given all sorts of ideas and suggestions, some of which I think range from the, sublime to the absurd. So, the thing is, we have to be careful, because with speculation running rife, we really ought not to reach for the panic button at this stage, because at the end of the day, I don't see that there is any basis to say that this can trigger Section 137 in and of itself, because the point is, regardless of how you want to look at the chain of events, if it is that it's the president's office which has officially sanctioned your approval for leave, then regardless of whatever the machinations may have been, it is not legally accurate to say that it's leave that you granted yourself. Because if essentially you had granted it to yourself, then why do you need to seek anybody's permission to head off on the leave? So I'm not sure that this in and of itself provides a sufficient basis for the executive to now say, well, we think this is a Section 137 type action. So it really is quite interesting at this stage because, of course, once you have this type of, strong display of power and executive authority, then, of course, egos come into play, and, it's a question of, a Kim Jong-un, Donald Trump type of situation.
Yes.
Mine is bigger than yours, kind of thing.
Yeah.
And,
So then it's a power play.
Considerations that determine how these issues play themselves out.
So it is a power play.
It's like 3-dimensional chess or 4-dimensional chess.
That's right. Yes, yes.
So if the Prime Minister and the Cabinet refuse to sanction the leave, and they say we are not going to pay whatever is permissible for an acting Chief Justice, does it mean that the Chief Justice will not be able to leave, Mr. George?
Well, on what basis would they be able to do so?
But but I don't know. The thing is, they have the power. The prime minister and the cabinet.
I've seen it's reported that the prime minister may have received advice from, preeminent senior counsel. Maybe one of the best, and that advice, of course, may be pointed in a certain direction. But that in and of itself is just what it is. It's advice. It's not a judicial determination of the issue. And unless and until you have a judicial determination or a judicial pronouncement, then you would have to be very circumspect in terms of saying, well, okay, look, because I got this advice, I am going to take a step such as this, because that could now trigger a backlash from the Chief Justice, whereby he could now file an action in court and say, hey, listen, you don't have any legal authority to do this. You don't have any court order to do this. You have an opinion, a legal opinion, but that is not a judicial pronouncement. There's a difference, So I've seen legal gymnastics taking place on the front pages of all the newspapers in terms of this issue, and I'm not sure exactly how people are arriving from, the premise to the conclusions that I see they are, freely spouting all over the place, with no care in the world for, the logical pathway as to how you get there.
Martin George, we have a couple interesting developments and additional pieces of information. One, it turns out there was approval for this idea of sabbatical by the cabinet that existed back in 2014. Mm-hmm. Two, it turns out that long before the most recent scandals involving the Chief Justice came to light, that he had actually applied for leave to go on this sabbatical. So
since November.
It's not as though he is doing this in response to things that have cropped up recently.
He was since November which year?
November 17, according to the report.
Yes.
November.
The point is, he was already neck deep embroiled in scandals then. So
with regard to Marcia Caesar, but the stuff concerning
that it's not, in reaction to.
But with the stuff concerning his private life, though.
Chasing his feet. So I'm not sure that to say that I applied since November last year means that it's pure. My intention is as pure as the driven snow. I can't see that at all. And the fact that the cabinet may have approved it, the question is separate and apart whether the president has the power to approve it. You see, and a different issue, because you also look at the you also have to take into account practical considerations, and while it might be something that may be legally possible, you also have to ask the question whether it is the best practical scenario in the circumstances that face us presently. I think, if one were to take a poll of public opinion, it might be interesting to see whether the public really feels that this is the best time for the head of our judiciary to be off on a sabbatical. I'm also not particularly enthused or, enamored with the choice of language that I saw in what purports to be the letter, whereby it speaks of rest and reflection, because I didn't understand the sabbatical in any way at all being for that purpose. While it may be for a revitalization of your mind, your creative juices, your thought processes, your learning and your knowledge, I didn't think that a sabbatical was really ever, in any circumstances, in any part of the world, designed for rest and reflection. I would have thought that a vacation is what you may be able to use for your rest and reflection if you wish, and you apply for vacation in the normal way.
But he has indicated that there is going to be a research project that he will be conducting.
Right, I know, but the thing is, in the letter, inherent within the bosom of the letter, is what we have seen publicly, if that represents the accurate, reproduction of what he said, then there is also that component. So therefore, I think on that basis, questions can be raised as to, well, is it proper to allow, a sabbatical, which also comprises an element of rest and reflection? In other words, is it permissible that anyone who is paid with the public purse, in that sense, could say, well, look, I need 6 months off, still pay me my salary, still pay me on my perks, my benefits, everything, because the point is, remember, you're talking about executive super grade accommodation, which the Chief Justice, the Office of the Chief Justice enjoys in Goodwood Park, at quite a hefty sum every month. And that wouldn't stop. All the support staff, all the ancillary payments, all those things keep running. So you're talking about 6 months of this, expense running, and you are saying, regardless of what the educational component is, you are saying in your letter, if that is correct, that you said that it's also for rest and reflection. I think there are some, accountability issues there in terms of, is it proper that we should be paying you and keep paying all these expenses while you go off to rest and reflect? Then all senior public servants could then say, well, hey, listen, I need some time off.
Because the precedent has been set.
Keep paying me my salary, keep paying me everything. Hey, if the head of our judiciary could be allowed to do so, why must it stop there? Then maybe the Prime Minister himself could say, hey, listen, keep paying me my salary. I need 6 months to go and rest and reflect. So that component in the letter troubled me. If it were limited purely to the pursuit of academic studies, that kind of thing, and of course then you also need to look at the question of the relevance, because it appears from what we have seen that a major component of it is something concerning industrial law and industrial relations, which again, we do have an industrial court, which is clearly distinct and separate branch, so it's not something that falls within the immediate and direct purview of the Supreme Court. So again, of course, you do have the opportunity for appeals from the industrial court to the Court of Appeal, but the thing is, there isn't that direct connection that one can say, well, yes, this appears to be an urgent necessity. Let's put it that way. So when you juxtapose that against the present circumstances, and of course, in the question of the exercise of one's discretion, you ask yourself, well, is this a proper exercise of discretion, both from the office of the Chief Justice and the office of the President? Of course, we must remember that our Constitution also has the ouster clause, which basically prevents you from inquiring into the exercise of the president's discretion and his decision-making in matters such as this once he has followed procedure properly.
And in the exercising of discretion, I'm glad you raised that, because I needed clarity, Mr. George, on a statement that was branded about by a learned, I think it's a SC. He made a statement that perhaps the CJ misled the president. Can you interpret that? How could a CJ mislead the president?
I was alluding to when I said, I've seen, these wild legal gymnastics occurring whereby people are jumping from premise to conclusion without showing us any logical path or common sense or legal reasoning to support their findings. And I think that definitely is one of them, because I have seen, along with that statement, no supporting evidence that can form that conclusion at all. So, I think we still do have a responsibility, even those of us who carry the title of senior counsel, if you understand me. That doesn't give you carte blanche to simply say whatever comes to your mind. There must be a certain level of, restraint and, responsibility that, accompanies your utterances, because the point is, if you can't provide the evidence to support such an assertion, then you could really end up making something that could end up being a defamatory statement. I saw another one suggesting something about collusion, and while you may want to think things privately, not everything you think privately is something that you can just utter and just put it out there in the public domain without engaging some kind of rational, reasonable thought process.
Meanwhile, back at the ranch, justice continues to be denied to so many people in remand yard.
Right, and you see now that is where I think the question of the reasonableness of the grant of the sabbatical comes into play, because these matters have not yet been determined, they've not yet been resolved. The whole Marcia El Caesar fiasco and what is happening with the 53 cases that are languishing, all these things remain unresolved. You have so many issues, you still have ongoing litigation because the Law Association has filed an appeal of their matter. So it just does not seem, I think, even to the fair-minded observer, that this is the most opportune time to go off on sabbatical. That's the nicest way I can put it. Of course, one doesn't know what exactly may be the ultimate motivation, but looking at it, I think, as objectively as anyone can in the circumstances, you ask yourself, is it really reasonable? But of course, as I said, when you look at the ouster clauses in the Constitution, we have to be very careful if we are entertaining the thought of, calling the president's decision into question. Now, the thing is, as I said, if it is that it can be shown that procedural impropriety occurred, then of course we have the case of Nizam Mohammed versus the state, whereby former chairman of the Police Service Commission, Nizam Mohammed, if you recall, he challenged the decision of a former president of the Republic to dismiss him from the post of chairman of the Police Service Commission. And the judgment of Justice Judith Jones, as she then was, indicated that, look, even though there is the ouster clause, and even though, the basic premise is that one cannot inquire into the actions of the president, if it can be shown ab initio that there was procedural unfairness or procedural impropriety, then that now takes it out of the ouster clause of the Constitution and allows it to be amenable to a question of judicial review, or, a circumstance where the court can consider whether proper process was followed, and the court can rule on that. So it's a fine distinction you're making in that you're not basically saying, well, the president's decision was wrong, because, you still have to show that respect to the office and respect to the constitutional provisions. But you're saying that, look, the process was wrong. And in effect, the decision would have to be set aside.
Mr. George, if after cabinet meeting tomorrow, the Prime Minister decides and communicates with the President that there is grounds for a committee under 137 to be formed to investigate the president, from a reluctant president and from a president who has just a couple more weeks perhaps in the office, as the case might be.
Well, no. Monday is the last day.
Monday,
yeah.
And a reluctant president, could His Excellency refuse to follow the orders of the Prime Minister?
Well, the thing is, I wouldn't put it so at such a high level as to say an order. I would imagine it would be a request, because I think that's the wording that we would use. It would be a request to basically trigger or invoke the provisions of Section 137. And given the timeline that we were looking at,
yes,
if it is that your term of office ends on Monday, if you get a request like that Thursday night or even Friday morning, then, I mean, there's more than sufficient opportunity to, either not make a decision at all, to say, well, okay, I'm considering it, and, you just basically let the clock run down. We see it happening all the time in the NBA, where, one side is ahead and, they're looking at the shot clock and, they just let the time run down because they know that, look, if it is that the other side doesn't get a chance to score, then they're declared winners. So, I would imagine that would possibly be an option if it is that you don't want to comply with that request, or you don't even want to have to consider it, and basically, it's going to fall at the feet of any incoming person. But the thing is, as I said, even the Prime Minister and the Cabinet at this stage, they would also have to be careful, because if it is that you've had statements from the Prime Minister previously that, he is not convinced that there's any need yet to trigger Section 137. And if you recall the judgment of Justice Kangaloo, which was delivered last week in the Law Association matter, where the Chief Justice filed action against the Law Association, that was one of the things that the judge latched onto. She indicated quite clearly that, look, the Prime Minister has indicated that at this point he has seen nothing to trigger Section 137. So then you have to now be very careful. Is it that this action is what has now caused you to trigger Section 137, and then now you have to justify, well, hey, is this by itself sufficient? In other words, is this an action of the Chief Justice himself, or is it an action of the President, which of course has conferred a benefit on the Chief Justice, that you are now seeking to attack? So it opens up a can of worms and a Pandora's box, and I would think that it would be I would think that it would not necessarily be the wisest step to take, given the previous statements of the emanating from the office of the Prime Minister. Because I think, you see, if it is that there had not been such a definite statement in the issue, then of course you could have said, well, look, I was considering all the other things before, and now this is now the icing on the cake, and I have decided. That would have been different. But I think there was a clear demarcation and a drawing of a line in the sand to say, look, all that you all have raised so far, nothing I have seen has caused me to trigger Section 137. So therefore, if now it's only this has occurred, then now the question would be, is this by itself sufficient? And I think that is going to be, such a fecund and, fertile and rich minefield of litigation that we will never see the end of it for the next 4 or 5 years, going back and forth with lawsuits, on
yes,
whether it is proper to even consider invoking it on this basis alone.
Martin George, we have to leave it there for now, but we appreciate you joining us on the show this morning and doing, such great analysis.
And Edison and Trinidad and Tobago. And, I always love the fact that we're able to have these discussions at an elevated level. We, of course, inject our human levity in the scenario, but the point is we are able to still tease out the major issues and have some rational, reasonable discourse on them.
Amen.
Thank you, sir.
Thank you so much, and have a wonderful day.
Thank you.
We've been speaking with Martin George, a member of the Police Service Commission and a senior attorney at law, right here on the Breakfast Roundtable on Sky.
In your car, on your phone, the Sky is everywhere. Sky 99.5 FM.